Hello, I'm Mark Latham. I'm a lawyer that's been providing legal services to the residents of Richmond Hill in York Region since 1994, making this my 20th year in business. Now, I provide services in the area of real estate, business, and wills and estates law. And the purpose of today's presentation is to provide my clients and prospective clients with some straight talk about wills and powers of attorney. One of the most often questions I'm asked by clients when they're using my office for other matters is, do I need a will? And my most common response is most people require a will and a power of attorney. Now, I want to start off with a word of caution regarding the advice I'm giving. That is the legal formalities and requirements for wills and powers of attorney, the consequences of dying or becoming incapable without them, as well as the tax consequences when the taxpayer dies, varies considerably between province to province in Canada, and even more radically between countries. So the advice I'm giving should only be relied upon relating to the province of Ontario and should not be applied to any other jurisdiction. And I have to particularly note that most of my clients come in with ideas about wills, powers of attorney, and tax consequences of death that come from American jurisdictions and have absolutely no application whatsoever to the Canadian law. When I started out this presentation, I made a comment. That was the question is most clients ask if they require a will, and my response is that I say that most people should have a will and a power of attorney. So the first part of my presentation, I want to explain the difference between a will and a power of attorney and why both are required. A will is a document that sets out what the person's wishes are upon their death, and in that document they also name the person that has their signing authority on their behalf. Now, wills for the most part have to be approved by the court in a process that is commonly called probate, in order to verify the validity of the will and the signing authority of the executor or the person named in the will. Wills are also the only document where a deceased person can provide for the care of their surviving children while they're minors, as well as their money. So wills only take effect when a person has died and often can only be relied upon once the court has confirmed the will through the process of probate. The power of attorney, on the other hand, is a document in which a person appoints somebody to make decisions for them should they become incompetent at a later date or at least in need of assistance. It is only valid while the person is alive. Now, a word on wills and powers of attorney, particularly what has transpired over the last 20 years. Over the last 20 years or earlier, people began living to be much older than they had previously, and the wills themselves had to be written in a way to deal with more change than earlier wills. And in addition, people were often becoming either fully incapacitated from a legal point of view or partially incapacitated in need of assistance from family members. And therefore, the need for powers of attorney has actually increased substantially in the last 20 years. Now, in order to address the main point of this presentation, that is, why would I need, or why does people need a power of attorney? I want to start out with a commonality between powers of attorney and wills. And that is the government puts in place some legislation to govern what happens when people fail to take charge of their affairs and have a will and power of attorney. And it's focused on putting the next of kin in charge of the person's affairs and when they die receiving their property. This leads to a common problem in both the power of attorney legislation and the applicable estate legislation, and that is the definition of family or next of kin. Next of kin is often based on either a blood or marriage relationship, and by necessity there are complications the minute the person is a common law spouse, a non-adopted stepchild, or in-laws. Many of these people, depending on the scenario, are not considered next of kin and may have no right to apply to assist a person, take over their affairs, or receive property in their estate. And if any of these situations apply to you, there's a greater need to have wills and powers of attorney than the average person. Now, to deal specifically with the issue of powers of attorney, we need to describe what happens if somebody doesn't have a power of attorney. If somebody doesn't have a power of attorney and they become incapable, the office of the public guardian and trustee automatically become the guardian of that person and their property. Now, there's a preference that the family take over that responsibility, and there's a procedure by which this is done with court approval. The downfall of not having the power of attorney is threefold. The cost of bringing the application to become the guardian of the person by the family is very expensive, much more expensive than the power of attorney is in the first place. The second aspect is the fact that in being appointed by the court, there's a requirement of ongoing supervision, which also costs money. And there's a third aspect that is not so often talked about, and that is the dignity and privacy issues of the person who's become incapable or at least in need of assistance for the family. If a person becomes incapable, there's a procedure by which the person's capacity is tested, and they're subjected to the accusation that they're no longer capable of managing their affairs. And in addition to that, there is the involvement of the courts and the public trustee's office in the family business. It's my opinion that this is not respectful of the person's both dignity and privacy, and is just as important a consideration as the costs above. People often find when they do have powers of attorney, they're able to step in and just provide the right amount of assistance that the person needs to continue to be in charge of most of their decisions. So that's it on the issue of powers of attorney, and I turn to wills. Wills, basically, when the default rules set in place by the government are kind of a one-size-fits-all solution. And like one-size-fits-all, at least they do something, but they usually don't fit any particular situation in an ideal way. So, as an example, the more complicated the family situation is or asset situation, the more one has a need for a will. But I think the best thing is to start off with an illustration of the challenges that face the typical family. A wife and husband with two and a half kids, if you like. Most people would assume that's simple, the legislation takes care of it, and there's no big problems. Quite the contrary. There are really 4 issues that arise in a typical family situation where a spouse has died, not leaving a will. The first, and they largely revolve around the way in which the Succession Law Reform Act distributes property among family members. And that is that if the value of the estate exceeds, by today's provisions, $200,000, then the amount in excess of $200,000 is in fact split between the wife and the children. So there are 4 very clear problems that flow from this. Firstly, most couples save their entire life for retirement, planning only to split the money with the kids or pass it along when they die. This premature splitting of the proceeds obviously can leave one of the spouses at a particular disadvantage. The second issue is the additional tax triggered by this partial distribution to the kids. When a taxpayer dies, it triggers all their capital gains. And the way I like to explain this to clients is it triggers all their capital gains, but at the same time, if they planned ahead, it's not a major problem because all their exemptions also stay in place. So the purpose of using the will is to leave those exemptions intact as much as possible. And the biggest problem is, or the biggest exemptions are, the principal residence exemption and the one we're talking about here, which is the spousal rollover, which exempts any assets transferring between spouses. And the third one doesn't really apply here. It's called the Canadian Controlled Private Corporation. So any assets in this example of assets over $200,000 passing to the children, in fact, are subject to capital gains tax, whereas if they're left to the spouse instead, they're not subject to capital gains tax. And at the end of the day, that probably, the delay of paying capital gains probably means that the kids are going to end up with more money when the parents are done. Now, the two other issues that arise really flow out of the situation where the children are minors, thus complicating this matter even further. The amount of assets over $200,000, if they pass to the kids and they're under 18, do not go to the children. They go to an office called the Office of the Children's Lawyer, who then assumes responsibility for the money. And the parent, who now has the primary obligation to support the children, does not have free access to look after the children in the way in which they want from a financial point of view. And I guess the last point ultimately is it doesn't make any sense to leave money to the government in that way when the person who is burdened with looking after the children probably needs all the financial resources that they can get to look after the kids. And that's the main reason why people need wills. Complicate that family situation a bit further, and the need is even more crucial. Now, I want to touch on a final point, and that has to do with the myths about estate tax. Most people's estate planning ideas, particularly if they haven't seen a lawyer, are based on mythical tax that typically has come through reading American material where the tax rules are very much different than in Canada. So I think it's very important to understand what the tax implications are in Canada when somebody dies. There's basically, in the province of Ontario, two taxes that come into play when a taxpayer dies. The first is a capital gains tax, and I've touched on it briefly before, and that is that when a taxpayer dies, it's deemed to have triggered all their capital gains. And like I mentioned, it also leaves all their exemptions in place. So the big exemptions are the principal residence is exempt, any assets left to a spouse is exempt, and the third one is a Canadian-controlled private corporation exemption. And really that is not something that can be done without the assistance of a lawyer and an accountant. The other tax that falls into place is something called the probate fee, or commonly called the probate fee. And it is the one that strikes terror in everybody's heart because everybody assumes it's a very large tax, when in fact it's an extremely nominal tax that in most cases is 1.5% of the value of an estate. The problem is the American taxes are much higher, and people fail to actually understand the Canadian tax system. And quite frequently they engage in behavior that is risky or creates higher tax consequences by trying to avoid the 1.5% tax. The common things that are done to avoid the 1.5% tax is gifting property to the next generation to avoid the tax. Well, that really doesn't work, because gifting property to the next generation under our tax laws is also considered a deemed disposition, and in fact usually, because it causes an earlier disposition, will cost the family and the taxpayer more money than the 1.5% probate fee. There's the fact that if parents transfer assets prematurely to children with whom they maybe don't have the best relationship or who are not mature themselves, that the parent loses control over their assets and really their lifestyle choices. The third thing is, and I've experienced this in my own practice, is that young people under the age of 40 are increasingly self-employed and engaged in businesses and things that expose them to liability. And by transferring those assets to the kids to avoid a 1.5% probate fee, there's the risk of exposing the family's assets to all these creditors, which essentially also makes no good sense. The other problem is about early dispositions, and that is gifting to children, is they deem it causes a disposition of the assets at fair market value. One of the things people often try to do is sell those assets at less than fair market value to their kids. But because of the provisions of the income tax, it usually results in double taxation, or paying twice as much tax than the family would ever have had to pay. And my final note about the myths about estates and taxes has to do with essentially the non-compliance aspect. A lot of advice given people by lay people about estate planning amounts to transferring assets on the basis that the government might not notice and therefore may not collect the tax, or basically some form of tax evasion. And it's quite common that I've had clients who come to my office with a clear idea that they're going to do something until I point out to them that it is essentially tax evasion. My caution to clients on this particular note is that the government has become increasingly able to track down the nature of such transactions because of the amount of electronic records that are typically available to taxpayers. And in my estimate, more than half the people who engage in these unreported transactions ultimately get caught, and they end up losing more money than if they'd followed the rules in the first instance. So I'm trying to highlight the importance of talking to somebody that is a lawyer, an accountant, and qualified in giving advice about estate planning, and not lay people. And I thank you very much, and I hope that you found this presentation educational and useful.